like that. Close it up. There we go. Okay. So today, all right, there we go. I think we are going to be on Notary Acts, right? Because we did reviewing the document last weekend, I believe. Yes, we did. Okay. So let's go to Notary Acts. Making sure that I allow everybody to talk on here. Good evening. Hello. Welcome. And Notary Acts is kind of big. Fees for notary services. Okay. So I think that we're probably only going to be able to do Notary Acts. What is this here? Florida law. Saying to the notaries public. Okay, so yeah. Looks like we're going to be doing just Notary Acts tonight. Okay. Oh, let's get into it. All right. So, of course, every state is going to be different with the type of Notary Acts that you can perform in your state. And I know that for those of you who have been a notary for some time, you do realize that they are different across the states, okay, of what you can and cannot do. So we're never to assume just because we can do something in one state that other notaries can do it in their state as well. So for Florida, we can do acknowledgments, certified copies, inventory, safe deposit box, jurats. We can solemnize marriage here, and we can take oaths and affirmations and verify vehicle identification numbers. Now, is there anyone in a state where they can do something in addition to, or maybe they cannot do everything that we can do here in Florida?
That would be Michigan. You have to be an official. I think they say you have to be ordained or official minister in order for you to do wedding officials.
Okay, an ordained minister to do weddings. Okay.
Yeah.
What about you, Donna?
I'm looking here.
Now, Valerie, if I'm not mistaken, you guys can't do copy certifications either, right?
Right.
Okay. What were you about to say, Donna?
Oh, I was looking at marriages here, and it's weird because I know that we can do marriages, but in here it says in Florida, Maine, Nevada, and South Carolina, notaries have the authority to perform marriages. In other states, the notary public may not solemnize nuptials unless the notary is also a member of the clergy.
Okay.
So unless something changed, I understood we could. So.
Oh, wow. Okay.
So I have to go back and look to see where the difference is.
Exactly.
But we can also do protests.
Okay. All right. Teresa, I see you keep going in and out. Are you having internet issues?
Okay, can you hear me now?
Yes, I can.
I was on my iPad, so I don't know what happened. It kept throwing me off.
Oh, okay.
But that was weird. Yes. Hello, just joining in.
Hello. Okay, so I was asking the question, is there anything different that you can do in your state that I did not name for my state? Here we can do acknowledgments, certified copies, inventorying. I don't know why I keep wanting to say interview. Inventorying of safe deposit box, jurats, marriages, oaths and affirmations, and then verifying VIN numbers.
far as I know, we can do all of those. I'm not sure about the VIN numbers. Are you guys on a certain area in your book?
Oh, yes, I'm sorry. We are discussing Notary Acts tonight, guys.
Well, awesome. As far as I know, all of those we can do in Ohio.
Okay, so you guys can certify copies in Ohio.
I'm looking on here now. Would you say certified what?
Copies.
Acknowledgements, oath and affirmation, deposition, subpoenas, witness, jurats, other notarial act, deeds, mortgages, contract, real estate property. I don't know about that one.
Okay.
You don't see anything about that.
No certified copies. Okay. All right. Now, as
Yes,
far
it says unauthorized act, certified copies.
so you cannot do it in Ohio either. The same with your neighboring state, Michigan. They can't do it either.
Yep, there you're right.
Okay. All right. Now, it does talk a little bit more about acknowledgments here. I won't go into depth about that. We all should know what an acknowledgement and a jurat is. Our customers won't, though. Okay. So sometimes I'll see notaries have listed on their website. I do acknowledgments and jurats. Your customers don't know what that is. So you don't need to put that. They don't know what an acknowledgement or a jurat is for the most part. Okay. Now, here they do have copies of the certificates. Now, I was trying to put together, and I'm going to continue working on it. I was trying to put together a spreadsheet for every state where notaries can go on there and they can see their state specific certificates that are allowed. Some states like Alaska, it just says that they use general certificates. So they don't even have them on their website, which is weird. But that's why every state is different. Now here for Florida, I do see copies of verbiage that we can use for each type of notarization. And it surprises me how many different certificates we have. My goodness, they have one for representative acknowledgement. We have the short form acknowledgements. We have corporate acknowledgements, partnership acknowledgements, attorney in fact acknowledgements. Anybody else have all of these different certificate types in their book?
Yes, Ohio has short form. Person signing on behalf of a partnership. Person signing as a public officer, trustee. There's several in here. Person signing on behalf of a corporate. So yes, there's several in here.
It's good though that they do have them, so that if you are asked to notarize a document that requires those extra, those specific notary certificates, you can provide it, right? You just got to know, who you're notarizing for and what it's being notarized for. So like here, representative acknowledgement certificate for Florida, it says this is used for a corporate officer, trustee, executor, or ex-executor is how you would pronounce that. Attorney in fact, guardian, or other representative acting on behalf of an entity or person. So it even tells me here when I would use these different certificates. What about for you guys? Does it tell you when to use these certificates?
I'm not seeing anything here, but it might be somewhere where I'm not seeing it. So,
Okay. I do know for you, you have your state handbook, right? Because that's more
correct.
accurate, right? Yeah.
Correct.
Because your primer is not. I was looking at your state handbook is definitely more accurate than what we're looking at. But I thought that they did have like a link. I think I put it on the spreadsheet for Montana where there's a link where it has all of your certificates.
Yes. Yeah. And it has all the different sizes and the for sticky or however you want it, labels, all that type of stuff, but we can get it.
Yes. I love that about your state. Just gives you everything you need. Now here, it does tell you that for acknowledgments, these do not need to be signed in our presence. Okay. And it does say that for Florida. Do you guys have anything different for acknowledgments, or is that across the board for all states of people that are here?
No, I think it. Let me see. I thought acknowledgements they have to be present also. Let me
Okay.
for sure.
That's why I asked, because I know every state is different. I'm not going to assume that every state, for acknowledgement, the person doesn't have to sign, because here in Florida, that's what it says. We don't have to witness the person sign the acknowledgement. They just have to attest that that's their signature. And this is for acknowledgements only.
That's how it is in Ohio.
Okay.
Here too, they can sign it, but you want to get their ID and stuff showing that they sign.
All right. Correct. Okay. Now here it does have a sidebar here. So it says out of state acknowledgements for Florida. Acknowledgement certificates completed outside of Florida by notaries of another state in accordance with the laws of that state may be recorded in Florida. However, acknowledgements completed in Florida for use out of state must substantially comply with the wording described in the statutes. I get questions about this all the time. Like, can I notarize a document that's not for my state? Yes, we can. You're not always going to notarize a document that is drawn up on your state, but you need to make sure you're following your state statutes on notarizing that document. The certificate may be something totally different than what you're used to for your state. So you have to make it state compliant. And if you're not able to, you got to attach the state compliant certificate. And then it does have here in my book for notaries in Florida that there are other officials that may take acknowledgments within the state. Anybody else have a list of that for their state? The different officials that can also take acknowledgments in addition to notaries.
I don't.
No?
No, I'm not seeing it.
I don't see that either.
Really? Okay, so here.
What was that listed under for Florida?
It says, so where it said identification of acknowledgement, then it says witness signature not required. It says out of state acknowledgements, terminology, and then it says who may take. I don't know why my video keeps going out. So it's right here. Can you see that? So it's right here where it says who made, and then it just gives me a list of other officials. So here it says, I wonder how can I stop that from doing that? Let me see. Conserve bandwidth. I just hate that it keeps doing that. Audio, video. Keeps turning off my video. I don't like it. Okay. So it says here, a civil law notary of Florida, a judge, clerk, or deputy clerk of any court, a United States commissioner or magistrate, and then outside of, but within the United States and its jurisdictions, acknowledgments may also be executed by a notary public of that state or jurisdiction. A Florida civil law notary, a U.S. commissioner or magistrate, adjuster in chancery or registrar, or recorder of deeds to any state, territory, or district having a seal. And then it goes further to outside of United States jurisdictions. Acknowledgements may also be executed by a notary public of the foreign jurisdiction, and so on. So it gives you a pretty good idea of what other officials are allowed, which is really important when a person cannot find a notary, right? Now let's move on. Moving on from acknowledgements. Now, for my state, I'm moving on to certified copies. Let me see. Is the screen blank or is there something wrong with my phone? No, you know what, Angelica? The freaking video keeps cutting out and I don't know why. Can you see me now? It's like I keep having to put
Yeah, you popped back on the screen like 3 minutes ago. I could see you. Sorry.
No, it's not. It's not you though. It's my computer. Like, ugh, I hate it. I hate that it keeps doing that. Let's serve. I don't. I don't know. I don't know, guys. I'm sorry. Okay, so for certified copies. Now here in Florida, okay, like this big debacle on what can how can you do a certified copy? It is recommended that we be present, okay, for the whatever document, and we cannot certify copies of vital records. Okay, now we don't have to be present when the person makes the copy. The person can make the copy, and but the person must bring us the copy and the original, okay, so that we can view both and make sure that this is actually a copy of this document that you're presenting to me. Okay. It is recommended that if possible, you make the copy of the original document. But if you can't, like if you're a mobile notary, you don't have that capability, the person can make the copy, and then they just have to make sure they come before you with the original and the copy. They shouldn't just be bringing you the copy saying, can you certify this? No, I can't certify that as is. Where's the original? Okay. And that's for Florida. Okay. Now, there's a list of vital records that we cannot notarize, and that is in here in the book or on the state website. So I won't go over that. But on vital records, we cannot notarize vital records. And there is actually a certificate that we need to use when we are doing copy certifications. And the certificate is listed here under certified copy certificate. Now let's see. Now, this is probably for every state. I think every state is allowed to provide copies of their journal records if requested by an official. Am I right?
Yes.
Okay.
Yes.
So here for Florida, it says that there must be a written request. If an individual desires a copy of a journal entry or other notary record, it is recommended that the notary require a written and signed request that specifies the names of the parties whose signatures was or were notarized, the type of document, and the month and year of the notarization. All of this must be given to us, and we must retain that copy when we are giving the copy of the requested record. Anybody else have any specific instructions for providing copies of their records?
I don't see anything in the primer for that.
I'm looking too. I don't see anything yet either.
No. Let me give you guys a minute to see if you can find it.
I found the area, so just give me a minute to read it over.
Oh,
here.
yeah.
Yeah. Well, didn't say much about it at all.
They could just request it.
Well, it talks. I thought it would say something. It says copying by employer, surrendering your journal security and disposal.
Gosh. What about you, Teresa?
It just talks about keeping the journal. In an event of a civil lawsuit, alleging that the notary's negligence or misconduct caused the plaintiff serious financial harm, a detailed journal of notarial acts can protect, well, it just says protect by showing a reasonable care, was used to identify signer. Okay. No, I thought it was going to say anything about that, but it didn't.
Right. So none of them say, well, Valerie, what about you? Trying to make sure I ask the people who I know are in different states.
It's. I think mine is pretty much the same. I haven't. I couldn't. I haven't.
Okay.
I haven't found it to read it, but when I read it before, it said pretty much that.
Okay. So it should be a written request. And I think that probably goes across the board. You know, someone shouldn't just be calling saying, hey, I need a copy of your journal entry. You know, you kind of like, okay, I need documentation for that, you know, so that because you have to keep that record saying that you provided that copy of your notary record. Okay. Now, inventorying a safe deposit box. I know not every state has to do it, but here in Florida, we do. And the purpose is, it says Florida law allows financial institutions, such as banks, to open a safe deposit box if the rental fees are overdue. Attempts have been made to notify the renter and has been received. A notary public is required to be present for the opening to inventory the contents of the box and to complete a certificate as evidence. Okay. And of course, because this is an act in our state, we do have to record it in our journal. And if no certificate is supplied to us, we can use the certificate that is given here. Can anyone else certify or inventory safe deposit box in their state? Is that a required act or no?
Can here, according to this, we can.
Okay.
We
So
can
it is an
witness
act. What about Ohio and Michigan?
I'm not sure. I don't see that, but I did run across. I did turn to the page where it says never surrender journal. Notaries should never surrender control of their journals to anyone unless expressly subpoenaed by a court order. So.
Okay, so then that's a written request right there.
Yeah. Okay.
It's funny she just said that because in Ohio, I just read that too. Never surrender your journal.
Oh, okay.
Thing she just said.
Wow. Okay. So it looks like Michigan and Ohio will have some similar.
Yeah, and it says even when an employer has paid for the
notary duties, then, huh?
notary official journal and seal.
Right.
Yeah. But I don't see so far. I don't see the. I know I read it, but regarding the mailbox,
Safe deposit box.
safe deposit box. Yeah, I read it before, but I don't.
Okay.
I haven't ran across it yet.
Okay. All right. Well, let's move on to jurats. Everybody knows what a jurat is. Okay. That is a sworn statement, you know, given by the signer. Okay. And it's a two-part act. Okay. So for the jurat, they must take an oath and then they're going to sign a sworn statement. Okay. And the jurat is the only act where it is a two-parter. Okay. So for acknowledgments, they don't have to take an oath, right? But for the jurats, they do. Okay. And not only do they have to take the oath, they have to also sign the sworn statement, you know. So let's see. In Florida, it's under jurat. It says, in notarizing affidavits, depositions, and other forms of written verification requiring an oath by the signer, the notary normally executes a jurat. While the purpose of an acknowledgement is to positively identify a document signer, the purpose of a verification with jurat is to compel truthfulness by appealing to the signer's conscience and fear of criminal penalties for perjury. In executing a jurat, a notary certifies that one, the signer personally appeared before the notary by presence or by means of audio-video communication technology at the time of notarization on the date and in the county indicated. 2, the signer was positively identified by the notary through either personal knowledge or satisfactory evidence. 3, the notary witnessed the signature being signed. So the jurat is the only one where they absolutely need to sign in our presence. And if the document has been signed before they met with us, they need to draw a line through it, or strike a line, however you want to say it, put their initials and date, and they need to sign the document again in our presence. And lastly, the notary must administer an oath or affirmation to the signer. Okay, so all those steps have to be taken for a jurat. It's quite different than what an acknowledgement will require, right? And then we have here the sworn statement, which is the jurat. Gosh, my camera just keeps going off. And it has the copy of the certificate here. Now, does anyone jurat certificate wording look different than what mine does? Mine starts off with sworn to or affirmed and subscribed before. Does anyone else say something different?
No, mine the same in Ohio.
It's subscribed and sworn to.
Okay, so yours is backwards, but it's saying the same thing, pretty much.
Yeah.
Yeah, same here. Subscribed and sworn.
Okay. All right. Very important to know, right? Okay. Now, it says here for Florida, wording for jurat oath affirmation. If not otherwise prescribed, a Florida notary may use the following or similar wording to administer an oath with a jurat. So I know sometimes notaries are like, okay, so when I'm administering the oath, what do I say? Well, here in Florida, we do have 2 questions that they give us. One where they're swearing to God, and one they're swearing on their own honor. So the first one, only swear that the statements in this document are true to the best of your knowledge and belief, so help you God. Then the other one, do you solemnly affirm that the statements in this document are true to the best of your knowledge and belief? Does anyone have this similar wording in their book?
Nope, I don't have that wording at all.
Oh man. Well, I do keep a copy on me. I made an index card. I no longer have to use it because I've done quite a bit of them, so I just know it by heart. But it is a good idea for those who are not notarizing regularly right now to do this for yourself. Have an index card. I even have it laminated, and I just keep it in my bag. So this way you won't forget what you need to say when you're administering that oath for the jurat. All right. We are
I have it in my bag with the laminated
good.
card.
And with some people, they have it taped inside their journal. Anybody have that?
That's a good idea.
Yeah. Yeah, I've heard some people, they tape oh, go ahead. What were you going to say?
No, I was just wondering if it was the same thing you just said. I found mine. It says, do you solemnly swear that the statement in this document are true to the best of your knowledge and belief, so help you God? Is that basically what you said? And then they have,
Yep.
do you solemnly affirm that the statement in this document are true to the best of your knowledge and belief? So that would sound a little
Perfect.
different.
Yes. Yep. I have the same statements. Yep.
Okay.
Remember, one is where they're swearing to God and one is on their own honor or belief. But some people, they'll like type it out and print it out. I have index cards because I have kids, so I just took one of their index cards and printed it on there. But some people, they print it on a regular sheet of paper, cut it out, tape it journal, so it's always there.
Yeah.
Now here in Florida, like I said, we can do marriages. Okay. So it tell us what we can do, how much we can charge, what the procedure is, and then on our own website, it actually has a bunch of information.
Oh, in Ohio, it says An Ohio notary is not authorized to perform marriages. We cannot.
Yeah, and
But if you were an ordained minister,
Yeah, I guess that's different.
like does it say that that you could be a member of the clergy? Because you know they do have you can become an ordained minister for free on the internet. Universal Life Church. If you go on there, you just fill out the form and you receive your.
Oh, okay. Well, I guess that's different.
yeah, and ours are
Yeah.
yeah.
Now
we-
here,
mhm.
you too, Valerie.
No, well, it says that where is it at? Unless they are also ministers. That's what it says. If you're not a minister, you have no authority to perform marriages.
Okay. Yeah. And the really cool thing about Universal Life Church is it does have it on there what states you can perform weddings being ordained through them and which ones you can't or may have issues. So good thing to look that up if you're interested in performing marriages. Now here in Florida, we do have both. So we have the ordained ministers and then we have the notaries. If you are a notary performing weddings, you can only charge the $30, but you can also charge whatever others charge a fee for whatever other services you provide, which most of them do provide additional services because $30 is just not enough for you to sit there for however long to perform a wedding, right? So many people do charge for other services in addition to just solemnizing marriage. But
So
if you are
could you charge? I've noticed that doing a wedding, sometimes they're late, and could you
Mhm.
charge a fee for them not being on time?
Absolutely. Um, I follow a guy, Alan Golu or something like that. I don't know how to pronounce his last name, but he has like templates, and I copy one of his contract templates, and in that contract, it does have that stipulation where I charge this fee for however many hours I'm going to be at your wedding. If you're late, I do this or whatever. So yes, as long as it's in your, contract that you give them and they signed it, then that means they agree to your terms, right?
Oh, hey, Virgil, how are you?
Hey, Reggie, good evening.
Good evening. And I actually just transitioned over to an officiant from Notary. I was doing loan signing and all that other stuff. And Virgil and I, over the last few months, have gotten to know each other. And she was there at the very beginning of my journey, transitioning into doing the marriages. And it is yes, to your point, it's all in what's in the contract, and I do have in terms of like I give them 2 hours for whatever fee that they charge, whatever package, whatever guest size they have, and then after the 2 hours is up, then a few things happen. If I have another wedding, then it's going to be canceled, and they forfeit whatever money they have already paid. The other option would be if I don't have a wedding, then every 15 minutes is $50. So, and I do that for the sake of them. Like, I want it to be expensive because if let's say the shoe was on the other foot and the wedding, I was late because of another wedding I had, what experience are they going to have? You know what I'm saying? So
Mhm.
the idea isn't to, I'm going to make bank if it's 15 minutes. Every 15 minutes I charge them $50. The idea is like, hey, we need to get it together within this 2 hour
Right.
period because you've had weeks, months, or years to work on it. At this point,
Mhm.
you're not concerned about my time, which is the most valuable because I'm going to focus on making sure that I do your wedding scripts and create all these things, prior to that. On that day, I'm ready. It's going down. It's happening.
Yeah.
So that's kind of the idea. It hasn't happened. And I've only been an officiant since my first wedding was August 1st. I've booked 9 weddings. And I have 20 already booked. So
Wow.
I've done 9 ceremonies, and then I have 11 more going into all of October, November, and then I have 2 at the beginning of the year. So, it's I hadn't had to implement that with anybody just yet. But, at the end of the day, if it come down to it, like, hey, you remember you signed that thing? Hey,
Mm-hmm.
it's going
Yep.
down.
It's in the
Is it?
contract. It's in the contract. So for anyone who is interested in becoming an efficient, remember, efficients work year round. Okay. It's not like notary. It's not. People get married all the time. So if that's something in addition that you want to add to your services, by all means, go for it. Now, oath affirmations. For Florida, it says the purpose is an oath is a solemn spoken pledge to a supreme being. An affirmation is a solemn spoken pledge on one's own personal honor, like what we just mentioned, right? In taking an oath or affirmation in an official proceeding, a person may be subject to criminal penalties for perjury should he or she fail to be truthful. So that is the whole purpose of having them. Hey, we got to say this, and a lot of notaries, especially when you're in a hurry and you're doing jurats, we don't do it. I'm guilty of it, in the beginning, but now it's just a conscious thing. Now, if I see jurat, I'm automatically saying, okay, because this is a jurat, I do have to have you swear or affirm that the contents of this document are true to the best of your knowledge. And then they say, oh, okay, yes, I swear affirm. Okay. And then we move on.
Roger, you don't do the oath until you come to a jurat.
Because remember, it's not really required for an acknowledgement, but
Right.
if I'm reviewing the document, I see the certificate is a jurat, then that's the first thing that comes to my mind is I got to give them an oath, or I got to
so
have
you
them
do it
recite an
right
oath.
then. Yeah. Okay.
Mm-hmm. Yeah. Mm-hmm. All right. Now, let's see. For Florida. So this is good to know. There are differences. Okay. They have wording for oath affirmation. They have an oath for an affiant signing an affidavit. Then they have an oath affirmation for a witness testifying in a court case. Okay. Those oaths are different, actually. And then we have an oath affirmation for credible identifying witness. Do you guys have those 3 differences in your book for your state, Ohio and Michigan?
I have, let's see.
Oh, and Montana too. Donna?
I don't have any of that.
No?
No.
I have, I do have the credible identifying witness.
Okay.
Then it says oath or affirmation for affiant
Yes.
signing an affidavit or the deponent signing a deposition. That's what you just said, right?
Mm-hmm. Mm-hmm.
Yeah,
Okay.
I have that.
Okay. What about you, Teresa?
I do have the wording for the jurat oath affirmation, and I have the oath or affirmation not administered.
What does that mean?
It says oath or affirmation not administered. Failing to administer an oath affirmation
Oh.
required by law, subject to the notary fine.
Oh, okay. Yeah.
Okay, never
that's
mind.
different.
Yeah, you wouldn't. Sorry about that.
Okay. Yeah, I had to listen to you say it a couple of times. Okay.
Yeah.
And then Donna, you say you don't have that? So they don't give you any different oaths to say for different circumstances?
No, they don't.
Oh, goodness. Okay.
I know I'm not too thrilled with this book.
I know, right? But I hope that those of you who don't have these particular things and you have those questions, make sure you're jotting it down so you can ask your Secretary of State or go on your state website so that you can see exactly what steps they want you to take, okay?
Oh, yeah.
Because it's really good to know if you come across that. I'm pretty sure you would come across at least 2 of the 3, right?
Yeah, I've done both the oath and affirmations. I've done those before.
What about for the credible identifying witness?
I haven't had to do one of those.
Okay. All right. Well, it's
But
good
she
to know
hears
they
from
have
me a
one
lot.
here.
My Secretary of State hears from me a lot.
I know. Oh my gosh. And they are awesome. So did you go ahead and sign up to do a committee or something like that for them? What was it?
I told her I was interested, and if they're trying to put it together. So it's just a matter of waiting and seeing what they do to put it together. But I told her to put me down that I was interested.
That's so awesome. That
Yeah.
is so awesome. Okay, let's see. To impress upon oath taker. All right, so that's that for that. Now we're going to move to affidavits. Okay, so for Florida, purpose of an affidavit, it is a signed statement made under oath or affirmation by a person called an affiant, and it is used for a variety of purposes, both in and out of court. Affidavits are used to make sworn statements for many reasons, from declaring losses to an insurance company to declaring U.S. citizenship before traveling to a foreign country. An affidavit is a document containing a statement voluntarily signed and sworn to or affirmed before a notary or official with oath administering powers. If used in a judicial proceeding, only one side in the case need participate in the affidavit process, in contrast to the deposition. Okay. So has anybody had to administer an oath for a court hearing?
No, not me.
Not yet?
No.
Okay. Okay. You can be asked to, though, if it's allowed in your state. Okay. Let's see. Now here, where it says depositions for Florida. A deposition is a signed transcript of the signer's oral statements taken down for use in a judicial proceeding. This deposition signer is called the deponent. With the deposition, both sides in a lawsuit or court case have the opportunity to cross-examine the deponent. Questions and answers are transcribed into a written statement. Used only in judicial proceedings, a deposition is then signed and sworn to before an oath administering official. Okay, so they will, you will administer the oath to them. It may or may not have a certificate. This is one of those acts where a certificate may not be present, but if you can provide the certificate, I'll say that. They have it here, a certificate for deposition. So if you know that you're going in to do a deposition, then take a copy of that certificate with you. Okay. If they provide one, it's perfect. But if they don't, at least you're prepared, right? And they do, and this is for Florida. I keep saying that because I definitely want to make sure that you guys are not thinking that if this is something you can't do in your state, that you try to do it. No, this is for Florida. They do have a copy of a certificate that notaries can use for depositions.
Okay, for Michigan, it says that Michigan law does not empower notaries to take depositions.
See, so that's why I keep saying, like, make sure I say Florida, because in your state you may not be allowed to. So Michigan can't. What about Ohio and Montana?
Montana, it says notaries without specialized training should not attempt to take depositions. Though any notary may swear in a deponent prior to giving testimony or execute a jurat on the already created deposition.
And that is totally different than taking a deposition. Taking a deposition is you transcribing a statement. Swearing a person in is just you administering an oath. So those are two different things, guys.
Oh, okay.
Yeah, they say the rest of it, leave it. They have trained stenographers or court reporters who are notaries, and leave it to them.
Yes. All right. Now, what about Ohio? Did Ohio say?
It says, although Ohio laws authorize every notary public to take and certify deposition, usually only court stenographers are called upon to do so. Recommend that a notary is requested, and to take a deposition, he or she should consult an attorney before deciding to execute this power.
Okay, and that's taking a deposition. But what about swearing a person in? Can you do that as a notary, or it says no to that? Because those are two different things.
You just said that. Okay.
That may be something you want to write down and look into.
It says for both depositions and affidavit, is that the same thing? A notary must administer oath and affirmation and complete some form of jurat, which the notary sign and seal.
Oh, okay then. So you can swear them in. You just cannot or should not transcribe the written statement for them.
And he
Okay.
must use the form, the jurat form. Is
Mhm.
that- Okay.
And does it provide a jurat certificate for you to use in that case for depositions?
It didn't say.
No? Okay.
Mm-mm.
See, like here in my book, it gives me an actual certificate wording right there that I
Oh,
can use.
no, mine didn't even provide wording. Oh, I
Oh,
see.
okay.
Certificate of deposition, that's what yours says.
Yes.
Mine said certificate of deposition, but then it says refer to page 31 and 33.
Oh,
So
okay. So maybe it has it over there for you, huh?
it does. I see it.
Okay. Oh,
Certificate for
perfect.
jurat. Yep. Certificate for jurat is a wording. The same thing, subscribed and sworn. Okay.
Okay.
It's done here. The
Okay.
next page.
Okay, good. It's good. That's why I asked you guys, because I don't want you to think like, well, it says I can't do it. But transcribing and taking the deposition is different than swearing a person in for a deposition. So as
I
long
know
as we know the differences.
some readers with these little words.
I know.
I didn't know it was that bad.
All right. Now we have the verifying VIN number. Okay. Anybody else, can they do that in their state? Verify VIN numbers?
Let's see. No, there's nothing about it in my book.
No.
Yeah, so far I don't see anything. Phone number, no.
Well, for Florida, we can verify VIN numbers. And it says the purpose. When a person applies for a Florida title on a used motor vehicle, a physical inspection must be done by an individual authorized to certify a vehicle identification number. Florida law authorizes a notary to make such a certification. The owner of the vehicle must swear before a notary that the VIN and odometer reading are correct. State officials explained that the Florida Department of Highway Safety and Motor Vehicles has issued new title forms to be used for new vehicles. These new forms do not require notarization, and the department has omitted the notary wording from the form. However, older title forms, which do require notarization, are still in circulation on older and used vehicles. Therefore, the notary should be aware of the differences and understand how to notarize the older forms if presented by a signer. So basically what we are doing is we are inspecting the vehicle to make sure that the VIN number that they wrote on there is correct. And we're going to make sure that the odometer reading on the car is correct. And then we're going to sign and notarize the document. Okay. And of course, you ID them and stuff beforehand as well too. And this is for Florida. Now we're on to the last piece here, and this is the fees for notary services. Does everybody have that?
No fees.
What's that?
Yeah, in Ohio.
You do? Okay. So there should be no question on what we can and cannot charge for services when it comes to notary, right? It says the following maximum fees for performing notarial acts are allowed by, in my state, Florida law. Acknowledgements, certified copy, taking inventory of a safe deposit box, and jurats are all $10 for each act. And we cannot charge more than $10 per act. So I know for some it's like, well, what if it's a two-part certificate? Like for example, they have some hybrid certificates that have been circulating where it'll have an acknowledgement, but it'll say that we have to give an oath. Okay. So then in your mind, you're like, well, I'm performing 2 acts, so I'm going to charge $20. But no, it's just a 2-part certificate. You're not stamping it twice. Okay. So for Florida, our fees is based on how many acts we performed. Even though you're taking 2 steps for that hybrid certificate, it's only asking for you to apply your stamp once. So 1 stamp is 1 act. If you have 2 certificates on there, then it's 2 stamps, 2 acts. Does that make sense?
Yep.
Now, for anybody else, do you have a difference in what it tells you you can charge? Like, is it per signature? Is it per act? Like, what is your requirements for charging?
It's per signature. It's,
In Michigan, it says per signature.
yeah, it just says a maximum fee of $10 is allowed by Michigan law. Let's see, Minister or permission witnessing or attest. Yeah, so it's just $10 for each signature.
Okay.
You know,
What about
it-
Ohio and Montana?
Ohio says maximum fees. The following maximum fees for performing notarial acts are allowed by Ohio. So we charge $5.
Okay. And is it per act or per signature?
Act.
Okay. So here it says acknowledgments for Florida. For taking an acknowledgement, the fee is not to exceed $10 for each certificate. For notarizing a document with 3 signatures, a maximum of $10 may be charged. However, if 3 certificates are used for the same notarization, then $30 may be charged. So ours is definitely per act. So however many times I stamp my stamp, that's how many times I charge you $10. So mine is not per signature. And they
Okay.
give the example here.
So help me understand this then, because see, this Ohio says acknowledgement $5 per document. It says for taking acknowledgement, the notary may charge no more than $5 for each document notarized.
Yes. So if you have 3 pages with 3 certificates, then you're charging them $15.
Okay, gotcha.
It says
So it's
each
per-
document that you notarized. So
Okay,
that means each document you stamped.
okay, I got you.
Okay.
And then we can charge, of course, traveling fees.
Yes, if that's allowed in your state.
Charges for travel by notaries are not specified by law.
Okay.
Such fees are proper only if notary and the signer both agree ahead of time.
Okay. All right. Anybody else have anything different for their travel?
No, my basic Michigan law does not set maximum travel fees for notaries, but it does indicate that the notary should inform the constituent in advance if a travel fee is going to be charged, and the signer should agree to the amount.
Okay. Now here, it does tell me marriages, like I said, for Florida, for solemnizing the rights of marriage, the notary may not charge more than $30. Oaths and affirmations is $10. So for administering an oath or affirmation with or without completion of a jurat, the fee is $10. And then here, verifying VIN numbers is $20. And it says here, since the VIN and odometer verification form requires the notary to perform 2 separate notarial acts, a sum of $20 may be charged. $10 for executing the jurat on Part A and $10 for completing Part B.
Virgil, I have a question. The Florida notary primer that I have says $10.
For verifying the VIN number?
Yeah, you said 20?
Yes, it says 20 in mine here. Now, I actually have done a few, and I charge $10 too because I don't see a Part A and Part B on there.
Yeah.
So maybe they're referencing an older form, but they have since released new forms. So right here, if you can see here, it does say $20 on mine, but
Yeah, I see it.
But like I said, I've seen it in person, and there's no Part A and Part B. So I've just charged the $10 as well.
Okay, gotcha.
Yeah. Now it does have here that we do have the option not to charge. Notaries are not required to charge for their notary services, and they may charge any fee less than the maximum, but you cannot charge more. It says overcharging. Charging more than the legally prescribed fees is reason for the governor to suspend a notary's commission. Okay. It does have here travel fees. Now, mine says the same thing as Michigan does for Florida. Charges for travel by a notary are not specified by law, so such fees should be charged only if the notary and signer agree beforehand on the amount to be charged. So we shouldn't be surprising our signers, once we get there, telling them it'll be $10 before we leave, and then get there, okay, well, that'll be 25. Well, why is it 25? Because I charge 15 for travel. Well, you didn't tell me you were charging 15 for travel, so I'm not going to pay for it. And that's their right. You need to let them know beforehand so they can decide if they want to work with you or not.
Mhm.
Now, do you guys have anything about absentee ballots in your book?
No, I don't think I've seen it. I don't really.
Okay. So for Florida, it says a notary may not charge a fee for witnessing an absentee ballot in an election, but must witness the ballot if so requested by a voter. So we can't charge for it, and we cannot deny a person the right to have it notarized. Not unless, they don't meet requirements. If I can't ID you and stuff like that, then no. If I can't ID you in any way, or if you are not going to be present to sign, you got somebody else doing it for you, all of those different things are reasons to tell a person you can't do it, obviously. But
So
you
I
can't
have
just,
a question.
yes, go ahead.
In the instance that would happen, so you can't charge any type of fee, but can you charge a travel fee depending on where the absentee ballot, let's say if it's in another county or something like that?
It just says here that the notary may not charge a fee for witnessing an absentee ballot. It does not say that you can't charge them for travel.
Okay.
Now, is
Now,
that something that you notarize? Absentee
No.
ballot?
yeah, it's
Oh,
looking like it. It's not in every state that it would be something to do, but in some states it does have it. So
Yeah.
clearly it does here. So I guess,
Yes.
yes. I've not done one yet. So I
now
can tell you how it looks.
because they don't have it in our primer, does that mean that we cannot do it?
Maybe it's not in your primer because it's not something that's required to be notarized, but unless you were asked to do so, you really don't know. Now, if I were you, what you could do is maybe Google a Michigan absentee ballot and see what it looks like.
Okay.
Okay. That's what I always do, especially if someone calls me, because General Notary is my baby. I love General Notary. I do a lot of General Notary. If a person calls me to notarize a document I'm not familiar with, I'm automatically going to Google. I ask them, what is the document? Tell me the description or the title. And then I Google it so I can see what I'm up against.
Okay.
Now, it does have here in our last part, unauthorized notary practices. Does everybody else's book have that for their state?
Yeah, I do.
All right. Let's see if we have any differences here, and then we'll be all done. So here in my book, it says proofs of execution by subscribing witness. Although Florida statutes address the recording of documents proved by a subscribing witness, the Florida Governor's Office states that a proof of execution by subscribing witness is not a notarial act. Okay. So unauthorized notary practice. And another one, the notary named in a document. If a notary public name appears in the document, we cannot notarize it. Okay. We can't notarize our own signature. And we can't be an interested party in the transaction anyway. Blank certificates. A notary may not sign and affix a seal to a blank notary certificate and then deliver that certificate to another person for the purpose of notarization. Okay. We should not, like sometimes when you do a loan signing, for example, they'll ask you to include a blank notary certificate signed and sealed by you in case they need to use it. That's not allowed. We cannot do that. That is not an authorized practice for notaries. It's actually against the law. So you should be telling them no. We cannot, in Florida, certify copies of vital or public records. Okay. And there is a list in the book here. And then you also have a list on our Secretary of State website. Another one is incomplete documents. Remember how I think I said it in reviewing documents section, where when a person brings the documents to me, I'm looking over the document to make sure it's complete. Okay. Why? Because it's unlawful to notarize an incomplete document. You should not be notarizing incomplete documents. Now, if somewhere on that document, it says that the missing information is going to be applied by someone else not meeting with you, that's the only exception. But other than that, we should not be notarizing incomplete documents, period. And that goes for any state. Now, mentally incapable of understanding. If the person who you're notarizing a document for does not understand what's going on, they're mentally incapacitated, and it has been ruled by court, then we should not be doing it. Okay, that goes with the willing and awareness part. For Florida, we can't notarize our own signature. We can't notarize without appearance. It actually says a notary who violates this law is guilty of a civil infraction and can be fined up to $5,000, regardless of whether the notary had fraudulent intentions. Then it says notarizing for relatives. For Florida, we cannot notarize for our spouse, son, daughter, mother, or father. Now, if it's a cousin, if it's my brother, I actually can notarize for him. It says right here in Florida, I can do that. And then lastly, no, I don't think that's last. Hold on, let me make sure. Oh, yeah, it is. Lastly, signing false names. A notary may not sign a notary certificate using any name other than the one under which he or she is commissioned. So I've seen this in a group before. A person wants to know, can they be commissioned under their business name? No. You can only be commissioned as your individual self. You can only sign under the name you are commissioned by. Does anybody have anything different than what I just read from my Florida statutes?
And that's under unauthorized practice of law?
Unauthorized notary practices.
See, all I have is unauthorized practice of law.
Okay, what do they got for you? Anything different than what I said?
Well, pretty much it do not assist others with legal matters. That's pretty much all.
Oh my gosh, are you serious?
That's it. I mean, there's verbiage. I mean, there's wording there, but that's pretty much the title of it. Do not assist others with legal matters, and it doesn't give anything else that you can't do.
That's what I have too, under that, unauthorized practice of law.
Well, mine doesn't even say that. It just says unauthorized acts, and it's pretty much got the certified copies and the marriages, and it just just got a little more detail regarding the certified copies, what not to do, and that's it. Nothing else.
I have that
gosh.
as well in Ohio.
Wow.
Yours goes into more detail there, but for Florida, geez.
I know, right?
You have a lot. You have a book.
Yes. Man. Gotta thank Florida for that, right?
Yeah.
All right, guys. Well, we are done. We're done.
Okay.
For tonight. So that was a lot. Notary Act. It was pretty thick. But thick, I mean. But it's good. It's good. How'd you guys feel about that review on Notary Acts?
It's good.
Yeah, I thought it was pretty good. Yeah.
Well, I thought it was
just
really
lets us
good.
know.
And
It just shows us
found out
what all the other states can and can't do, right?
Yeah.
So none of us should be in a group when a person says, I'm in so-and-so, can I do this? No, you can't do that. And you're in a different state.
Right.
Like, no, don't do that. Let them have someone from their state answer that question. Also, I don't know if you guys saw, I do have a survey in the group. I am going to be going ahead and dissolving the original support group because I do want to have a group full of active participants who have a interest in their development as a notary. Okay, so if you have not seen the survey, definitely go on the page. If you want to be moved from the old group to the newer group, you got to fill out that survey. It's 17,000 people in the group. I'm not going to remember you. So if you don't fill out the survey, I'm not going to know you want to move over to the other group. Okay, so please make sure you do that. And then I think our next time we meet is
Sunday.
That is the second, right? Okay. Yes. All right. So I will see you guys October 2nd. Yeah, because I wanted to make sure it wasn't my birthday. I thought I was gonna have it canceled, but my birthday is on the 8th.
Okay.
Happy birthday.
So thank
Yeah,
you.
happy birthday.
So our next meeting will be after that. So that's good. Thank you guys. All right. So thank you so much for tuning in tonight. It's been recorded, so I'm definitely going to post it after I, maybe edit the first part of it. But other than that, I will see you guys next Sunday, same time.
All right.
Thank you.
You're welcome, guys. Have a good night. Bye.
Good night.
Bye.
Bye.
Like